Our next speaker is Inyoung Cheong, a postdoctoral researcher at the Princeton Center for Information Technology and Policy. Her research focuses on developing practical socio-technical safeguards for AI systems, combining legal scholarship with empirical methods. Cheong's work appears in leading venues, including FACT and Artificial Intelligence, Ethics, and Society, among others. Before entering academia, she spent 8 years regulating emerging technologies at South Korea's Ministry of Culture and Korea Communications Commission. Inyoung Cheong's talk is titled AI's Cognitive Threat. Here's Inyoung Cheong.
Sorry, I made Julia to I tortured Julia for the pronunciation, but yeah. Hello everyone, I'm Inyoung Cheong, a postdoctoral researcher at Princeton CITP, and my background is law, and throughout my PhD in Seattle, because I was in Seattle, I was the only law person in the room, surrounded by a bunch of computer scientists who don't really know what I was talking about. But this is the very first conference where I was able to meet so many like-minded people, and I'm sincerely grateful to all the organizers, including Julia, to prepare for this meaningful event. Today, I will be discussing AI's cognitive threats, and I will cover 3 main points. First, the AI's manipulative power over human beings. Second, how it is frustratingly difficult to address these serious threats with legal tools, especially reflecting on the recent development of First Amendment law. And third, in a cautiously optimistic way, I will show you how the human-centric interpretation of First Amendment law can help facilitating more productive conversations over AI regulation. This research emerged from conversations with my colleagues, and we convened an expert panel in the early hype of ChatGPT to envision harm scenarios that could arise in near future. We came up with the scenarios of educational disparities, propagation of bias, polarization of online communities, emotional over-reliance on AI chatbots, and virtual sexual abuse if AI was connected to the virtual reality. Among these scenarios, I was struck by the possibilities of gradual disempowerment of human beings, the loss of agency, and how strikingly difficult to address these questions and even define the question legally. With cognitive threats, I mean the gradual processes where AI diminishes humans' ability to think, because my colleagues in legal communities couldn't believe that it could be happening, and so I initially prepared for a lot of empirical evidence that computer scientists endeavored to put together for the past few years. But after attending yesterday's sessions, I realized that these are too obvious to this knowledgeable audience, so I took up everything. So for those interested, you can find my original slides by scanning this QR code. So there could be many different manipulation scenarios in today's talk. I do not talk about the cases where malicious actors or information operations utilize AI to commit fraud or spread disinformation. Instead, I'm interested in cases where AI inherently exhibits manipulative behavior in human-AI interactions. So even when it was not explicitly programmed to manipulate users, but they do anyway. And this could happen due to various factors such as biases in training data, or through flattery, increasing user retention, or sneaking in some new ideas, as Aspen yesterday presented amazingly. And compared to cases involving malicious actors, these inherent risks are actually more difficult to conceptualize legally because it's not easy to find accountable parties. So this is the problem space I've been mulling over for the past couple of years. This is one of my favorite quotes from Norbert Wiener, who coined the term cybernetics, which is no longer being used. But he wrote in Science in 1960 that, like many other early AI researchers that were quoted in other sessions, complete control and complete intelligence just not go together. Because we want our agent to be sophisticated, they will be more difficult to control and even prioritize their own interest over ours because they will behave like just any other living species. as a law person, I naturally think, can laws do anything about this serious problem? The quick answer is not easy, and to guide our discussions, and let me introduce, sorry, my script is gone. To guide our discussions, and let me introduce Robert Kagan's framework comparing adversarial and regulatory framework. The adversarial framework centers on private enforcement, where norms emerge through disputes between opposing parties. In contrast, the regulatory approach relies on government agencies to establish the interpretation of laws through administrative actions. While no country exclusively follows one approach, the United States tends to lean more toward the adversarial approach. So let's consider a scenario where someone engages in self-harm due to AI manipulation, something that's already happening with concerning frequency. Under an adversarial approach, one might try to hold the AI company liable for marketing a dangerous product. However, as future lawsuits will likely demonstrate, convincing the court for that claim is incredibly difficult. You must establish both that the AI company could have foreseen the risk and that the AI interaction was the direct cause of self-harm. This becomes particularly challenging given the numerous compounding factors in those fact patterns. So there are two structural reasons our legal system has developed to address tangible harmful outcomes, not purely cognitive harms, and to penalize intended bad actions versus mistakes or negligence. Regarding AI's cognitive harms, not fully under the control of AI developers, do not fall under the purview of traditional legal protection. But there is a rare example that some parties could convince courts, like the Snapchat speed filter case, and teenagers were killed due to the fatal accident while racing cars to record high speeds on the app. And lawyers successfully proved causation by showing messages like, "I'm going to rock and we are going to win this battle." But this level of direct causation is very exceptional. When we consider the gradual empowerment where AI's influence is subtle and incremental, proving such direct causation is almost impractical. Another approach is regulatory, like prohibiting manipulative technologies and delegating administrative agencies to enforce that clause, which appeared in the EU's Digital Services Act, Article 25. This regulation appears aimed at banning dark patterns in social media, and we could consider adding similar provisions to the AI Act. However, imagine implementing such regulations, you would probably need to prove that the AI service providers was aware of the manipulation possibility and deliberately took no action. So while not as challenging as proving product liability, it's still quite difficult because AI companies can argue they've done their due diligence by passing evaluation benchmarks. Alternatively, we could prohibit situations likely to create manipulation like emotion detection in workplace or educational settings like EU AI Act did, or we can consider more procedural requirements instead of prohibiting some substances such as risk assessment, transparency reporting, and third-party auditing. Although all approaches have their own drawbacks, and I believe a regulatory approach like the EU AI Act or Digital Services Act would be more effective in steering AI development to take AI's cognitive threats more seriously. I want to note that the adversarial private enforcement's most destructive aspect, we need to wait until something really bad happens. So like Snapchat case, someone should die. So as Benjo indicated yesterday, isn't it too costly to wait until AI has diminished human agency entirely on a massive scale? So we need to do our best to come up with every possible way to send a clear signal that it's not okay. So we need to reject that AI's cognitive threats. So I was genuinely thrilled by many researchers about their looking for many ways to evaluate dark patterns and manipulative behavior of AI systems. So I believe this kind of work in understanding and detecting AI models' manipulative behavior can start really meaningful discussions. But I want to give you some frustrations that I face as a free speech scholar because First Amendment poses the biggest hurdles on safety regulation. So let's imagine some kind of the safety regulations come into force, although it's not likely, at least in the United States, given the political climate, but let's assume that it happened. And do you think AI companies would happily comply? How many of you think that they're going to comply and they wouldn't say anything? One person, okay, great. So I highly suspect, and although AI companies like OpenAI openly claim that they welcome regulations, but they will change their words. We meant good regulation, not nonsensical regulation, something like that. So I believe that they would likely claim First Amendment arguments. And unfortunately, it can be a winning argument. And a little bit counterintuitively, AI companies would claim violations of their own free speech rights, and specifically their own editorial discretion, just like social media companies have done. So how can it be even possible? Does the First Amendment inherently protect people picketing on the street or distributing pamphlets? So we need to look into why this is possible in the US First Amendment history a little bit. The original First Amendment cases emerged in 1920s, a little surprisingly recent, not in an AI publication calendar, but in a normal human calendar. Before then, the court didn't just mention the First Amendment that very much. Back then, the court's main concern was what we typically think of protecting religious pamphlet distribution or not penalizing people for their connections to the Communist Party or allowing students to wear anti-Vietnam War symbols. I see this era as a Rawlsian principles where the Supreme Court protected expressive freedom of little people. Then came to the balancing era between public interest versus private speakers' rights, some hints about the listener's right to receive information. So in this era, the courts were dominated by mass media and advertisement cases. For instance, the fairness doctrine required broadcasters to present opposing viewpoints on matters of public significance, like elections. The court upheld this FCC regulation, but later struck down similar rules for newspapers, reasoning that newspapers are too many compared to broadcasters, so they have to have some more editorial discretion over their content. Finally, we entered the era of formal equality that was coined by Genevieve Laquier, a legal scholar at Virginia Law School. After the notorious Citizens United decision recognized corporate campaign contributions as speech, the Supreme Court began treating commercial speech as worthy of protection almost equal to political speech in our capitalistic society. So the legal scholars do not really like that conclusion, and especially AI companies are going to claim that their AI alignment techniques are editorial discretion. They want to take down certain content, make AI to refuse certain content, and so if their content moderation or AI alignment or safety measures were regulated, it's going to be even more harmful, something like that. And so legal scholars try to say that the First Amendment does not protect human replicant. AI outputs are not protected speech, or parameters of models are not protected speech. And recently, there is a speech certainty article in Stanford Law Review that because AI models don't really know what they're talking about, their speech is not protected speech. But I wondered why all these precise linguistic matters matter, and so do we really need to do all this thinking to fathom that AI outputs are not protected speech, and why First Amendment became so mechanical that if it falls under some sort of speech, then everything is protected, and if it is not, and everything is not protected. So it seems to be too binary to me. So I went back to examine over 100 major free speech cases from scratch all over again, and it's not the most pleasant experience, but in general, I'm skeptical of how Americans tend to fantasize about the founding fathers or their Supreme Court justices. But however, for this time, after looking through all these cases, I concluded that existing Supreme Court precedents could give a much more promising interpretation, one I would call a human-centered First Amendment. The key is shifting the balance slightly from the notion of singular speaker to different levels of speakers. And instead of just focusing on the right to speak, we should focus more on the right to formulate our ideas, the right to read, and the right to receive the information. And also the biggest concern has been, at least in the First Amendment doctrine, has been the government's censorial motive. But as Bertrand Russell said in this Freedom of Thought lecture in 1922, and also Professor Stiglitz highlighted this morning, economic pressure and information operations are real threats that pollute the marketplace of ideas. Given the monopoly status of a handful of leading AI companies, it is possible that the public doesn't have a meaningful choice of selecting the information sources anymore. There is a half-dead but fascinating doctrine called captive audience. And so I wanted First Amendment be more contextual, taking into account power dynamics between speakers and listeners. Does this sound like just common sense to you? Why does this woman do all the work only to reach such obvious conclusion, not novel at all? So if you feel that way, I'm very happy, and I hope that this will be common sense to the courts and legal communities too. In 2022, I focused on cases involving individuals, mass media, and advertisements. But this time, I broadened my search scope and discovered that case law has evolved around 5 key institutions that significantly influence our belief system, knowledge, and perspectives: religion, schools, libraries, media, and advertisers. These institutions all have great influence than individuals and frequently become subjects of First Amendment disputes. For example, government funding of institutions is generally justified under spending power, but it's not justified for religions because the government shouldn't be entangled with a specific religion. It's also unconstitutional to force school teachers to teach creationism or intelligent design or prohibit them from teaching certain languages. Libraries are particularly interesting. These seemingly harmless institutions have become major battlegrounds for lawsuits in today's America. Most notably, there are ongoing disputes about state governments attempting to prohibit librarians from carrying LGBTQ+ related books as objectionable content for kids. These cases are being intensely debated in lower courts, and President Trump recently declared book bans as fictions, and so we shouldn't care about it. But there is only actually one Supreme Court case on this issue, 1982, Board of Education versus PICO. This case established that students have a constitutional right to access information, and school officials cannot remove books simply because they disagree with the ideas in the book. For mass media, as mentioned earlier, courts both uphold and strike down regulations depending on the media's influence and public interest purposes. While they struck down newspaper right-to-reply regulations in Tornillo, they justified must-carry rules for cable operators in the 1997, citing their bottleneck control power. Regarding advertisers, courts almost always base their decisions on the flow of information. They do not care much about help maximizing advertisers' reach to potential customers. Rather, they strike down content-based regulation because it prevents people from accessing information necessary for their purchasing decisions. This is a little legal technicalities, and so I wouldn't really explain it, but at least you can see that these intermediary institutions are basically knowledge and thought facilitators instead of an individual speaker. They are, of course, speakers. There are teachers, librarians, and advertisers. All of them have speech rights, but their main function is facilitating speech and serving the public. And so the courts always reason that the government's action over these intermediary knowledge and thought facilitators for the sake of the public, believers, consumers, non-believers, patrons, students, and subscribers. So how can you apply this framework to AI regulation? So evaluating AI regulation through HCFI, Human-Centered First Amendment, first, the government could provide research and development funding or procurement for government use to AI companies while mandating certain conditions. Personally, I strongly support establishing an AI subject review board. As Maria Ressa keenly described yesterday, all of us are in a massive social experiment now, and human subjects are entitled to be protected. This isn't unprecedented. We academics are required to conduct tight procedures to assess the potential psychological risks to human participants in our study. When institutional review boards were first mandated, and scholars and schools resisted attempting to claim academic freedom under the First Amendment. However, given the proven harm to human subjects, like in Stanford prisoner study or Nazis, some experiments on human body, so these regulations prevailed. Beyond this, we could implement a range of different safety measures. We could require AI service providers to identify and mitigate manipulative behaviors through guardrails, or implement clear labeling, or reducing the burden of proof for the AI's cognitive threat cases. We could also regulate AI anthropomorphization and restrict emotion detection capabilities. And AI's exploration of user vulnerabilities for marketing purposes as misleading advertisements. So when AI is engaged in professional services, we could also apply fiduciary duties to ensure it acts in the user's best interest. So I know the devil is in the details, and we will need many conversations to determine which measure is the most appropriate. But I believe these collective efforts at the societal level align with a human-centered First Amendment, and the conversation should be encouraged instead of worrying too much about harming the innovation. Thank you very much.
Thank you, Inyoung Cheong. Let's take some questions. Yeah, do you want to come up to the mic?
Thanks for the talk. I think these are very important questions to ask. My question is a bit of a challenge. Is what about contestation? So we have a situation in which we automate a lot of parts, but for an individual to actually object or contest to some kind of a service they have received from a social media platform or any kind of a cognitive technology, let's call it that, this is a very difficult process because it still goes through a system that is basically people who have to carefully think about things.
So right to contest?
The right to contest, and how is it actually operationalized in a world in which creating contestations is much faster than seeing to them, because the institutions that have the right, they have the duty to process contestations, don't have the capacity to handle the amount of violations that can happen.
Yeah, help me to understand. So is it like similar to notice and takedown regimes?
What I mean, for example, is let's say that your image appears, what Maria Ressa showed yesterday, like your image is used as if you are selling some product that you have absolutely no, not connected with, and then you want this taken down, for instance, or you want that people don't use intellectual property that you have in a way that you have not given them the right to do. Any of these cognitive crimes, let's call them that. So of course you have the right to contest, right? So you fill in a form and it goes somewhere. And of course the body that is processing all of these forms does not have the capacity to handle them all. So we create a system in which it is very easy to create these crimes, as it were, but it's very difficult to process them. So do we need, let me refine the question maybe, do we need to expand our laws to allow for different type of contestation processing in order to keep up with all of the issues that happen?
Is the low resource organizations facing that problem? So what I could think of are kind of the major social media platforms or the big AI companies, and I submitted some kind of form to Stability AI because Stable Diffusion seemed to use some images, but I didn't really get any response from them. But Stability is kind of small, but other social media companies are kind of big enough to process all those notices and claims.
They don't have to, is my point, right? I mean, there needs to be a law that forces them to have to.
Yeah, this is an interesting question, actually debated in the U.S. courts, and so there is a possibility that actually the current law already, at least in the U.S., already mandated removing the watermark as illegal. So they had to respect those kind of contests, but it's just technically very difficult. That I was told that the researchers recently, probably there are many people who know this matter much more than me, but they kind of wanted the machine to unlearn. So because like just taking off certain problematic information from the huge training data and retraining models are just economically doesn't make sense, almost infeasible. And so they wanted to make it unlearn, but unlearning is also not very successful, and still researchers found a way to kind of jailbreak those unlearning, and they found out that the information is still there. And so it's technically very, very difficult, but I think from the legal perspective, if that is the violation of law, and if that is the property law or contract law or IP, any kind of violation, still law should find a way to enforce it, even though it's technically infeasible.
But, I mean, technically it's infeasible to raise somebody from the dead as well, but we have recourse in the law to compensate for this type of irreparable, you cannot make it good again kind of events, right?
Yeah. Yeah, I agree. And unlearning would be difficult, and maybe it's not perfect, but I'm pretty sure like mitigation efforts always can be taken account in the court's proceedings. So if they try to mitigate those and by just using all the technical methods that they could use, and I think that could be a good defense. But normally, I think, in a normative way, I think still law should be law and it should be enforced and all. Yeah.
Thank you for your answer.
Thank you. We have time for one more quick question.
Thank you for your presentation. I'm wondering, do you believe that U.S. case law through the Supreme Court has established a First Amendment right for corporations to process personal data under the auspices of free speech?
I think it's not settled yet regarding processing data, at least. Yeah. So processing data is different from content moderation, right? So content moderation is just one way of expressing the company's policy, but processing data could mean so many different things. And so there is a legal scholar who tried to argue that data processing should be protected by free speech, but I don't personally think that that is right. That is just too broad to me, and also I don't think that it's yet settled.
Thank you.
Thank you so much, Inyoung Cheong.